This is an interview with Lori Richards for the SEC Historical Society's Virtual Museum and Archive on the History of Financial Regulation. Today is July 16th, 2021, and I'm Kenneth Durer. Lori, thank you very much for taking the time to talk today. I appreciate it.
I'm really happy to be here, Ken.
I always start out with some background, and let's go back to your undergrad experience because that sort of sets people on their path. So let's talk about how you got on your path.
Sure. I went to Northern Illinois University. I graduated in 1982. While I was there, I studied political science, and I became interested in public policy and politics, and started a bunch of clubs, political-oriented clubs there, and loved my experience at NIU. I had some very inspiring professors. And then I determined when I graduated that I needed to go to law school in order to really make a career in public policy. So then I went to American University, Washington School of Law, and I went there because it was in Washington, D.C. My family was from the Midwest and Toronto, and I really needed to come to Washington, D.C., I thought, in order to develop some expertise and experience in public policy. So I went to Washington College of Law and really enjoyed my time there. I graduated in 1985.
Okay. So how did you sort of turn from public policy towards securities law?
Well, they're really not different. I was interested in public policy as a way to do some good. I took a securities law class with Professor Mary Siegel, and I was really inspired by it. My father was an accountant and treasurer of a public company, and my mother was very interested. She was also an activist, I would say. So the combination of the two, I think, and Professor Siegel's class really inspired me. I remember studying for her final exam, and I had a big whiteboard behind me, and I think I stayed up all night, and I wrote the history of the securities law in tiny little letters, starting, I think, at the top with Howie, and then, and I did it from memory. And I'm sure now it was crazy. It was lack of sleep, but it was also passion. I really was inspired by securities law. And I interned at the SEC when I was in law school, and had a good experience doing that, and decided, I guess that was my second year or my third year in law school, that I really wanted to work for the SEC because it was a good blend of my interest in finance and securities and public policy.
Tell me about the internship. Where did you work?
I worked in the then Washington Regional Office, which was here in Arlington in Ballston. And I expected that staff attorneys would be hanging around the hallways arguing the finer points of securities law. That's what I really thought it was going to be. It wasn't quite like that. But I got a sense of what it was like to work for the SEC, how the SEC was structured. Overall, I had a positive experience.
Did you work on some cases?
I was an intern, so I did like document organization. I didn't have a lot of exposure to big picture cases or issues there.
Right. So did you decide to go right into the commission after that?
I did. I was my third year of law school. I applied to all of the commission's regional and district offices. So I don't know how many there were then, 14 or something. Every single one, there were paper applications. And the first office that interviewed me offered me a job. It happened to be the Los Angeles regional office. I would have gone anywhere, to any office. But they offered me a job, and I accepted it right away. And summer after I graduated, moved to Los Angeles and started at the SEC as a staff attorney in the Division of Enforcement in September of 1985.
Why did you apply to all the regional offices? Why not headquarters?
I think I did apply to headquarters as well.
Okay.
I believe I did. As I said, I would have gone anywhere. I didn't know so much about headquarters. I didn't know about the different regulatory divisions. I was familiar with enforcement. because of my internship in case law. I would have gone, as I said, I would have gone anywhere. But Los Angeles was the first to make me an offer.
Right. So was it the Pacific region at this point? Is that what it was officially?
Yes. Okay. I mean, LARO, the Los Angeles Regional Office, was what we called it.
What you called it, yeah. The nomenclature gets confusing through this period.
It does. Yes. There were some changes.
So, were you just in part of the enforcement team? What was your title?
I was a staff attorney, so that's the entry level. I think I made $37,000 a year, which was a lot for me. Even living in Los Angeles, it felt like it was a lot of money. And I loved it. I got experience right away. I had my own cases, my own investigations. I learned a lot the first couple of years. They had a protocol where they had so many investor complaints that twice a month staff attorneys were responsible for doing intake. People would just stop by the office and talk about their experience, how they felt that they'd been defrauded. And so I learned a lot from people who came into the office to complain that someone had stolen their money. And it was something that nobody really liked to do. Staff attorneys didn't really like to spend their time doing that, but in retrospect, I learned a lot. And it helped me have some personal experience with people who felt that they had been defrauded. So I was a staff attorney for 2 years, and I had my own cases. My first enforcement case was against a radio guru who was trying to sell people gold, who actually stole their money, and it was a good experience because I took the testimony. You know, I had a branch chief, but I was the one that was taking the testimony, reviewing the documents, writing the subpoenas. It was a lot of experience for a new attorney right out of law school, and I loved that.
Who else did you learn from during that period?
I had very good colleagues. Elaine Kacharis was my good friend, and she eventually became the regional director of the office. And I had another very good friend, Rose Schindler. And we were all doing our cases, but we talked all the time about strategy and securities law and how to get things done. We were wanting to bring cases, wanting to be activists and bring cases. I worked with some great regional directors. I worked with the U.S. Attorney's Office quite a lot. A number of my cases became criminal investigations, so I worked closely with Jim Asperger and James Sanders from the U.S. Attorney's Office in Los Angeles.
Was that a pretty easy working relationship? Were they used to plugging into SEC regional stuff?
Yes, it was very routine, and also with the California Department of Corporations. We routinely shared information about all of our cases, so they had the option of investigating it with us or just so they would know what we were doing. And so they would take a fair number of our investigations on as criminal investigations. So I worked with the postal inspectors when I brought my first case, and they went in and did a seizure of all of the documents of this investment guru's offices. And I remember, part of my investigation was sitting in a warehouse looking at all of the documents that had been seized, a cold, dreary warehouse, and finding evidence. And so that's very heady, for somebody right out of law school.
Was there a common denominator? Was there some kind of fraud that was prevalent in LA?
Yes. So I was there for a total of 9 years. And offering frauds were a lot of offering frauds. People selling securities without registering the securities. A lot of broker-dealer fraud. There were a lot of boiler rooms in Southern California. It was a lot of money, right? A lot of retirees in that part of the country, a lot of money, and that's where the money is. So that there were a lot of brokers who defrauded clients. A lot of Ponzi schemes. We did a fair number of TROs. I think in the time period that I was in Los Angeles, those 9 years, I think we brought more temporary restraining orders in court on an emergency basis, looking to shut down offering frauds and Ponzi schemes. I think we brought more than any other regional office, and it was really just an indication of the types of frauds that existed in that part of the country. We also And in addition to Southern California, we covered Hawaii, Oregon, Washington State, Arizona. I think that's it. So we traveled across the region, and there were a wide variety of cases, but the bulk of them were offering frauds.
Yeah, it does sound daunting to be in LA and be responsible for Alaska.
Right. Right. I never had a case in Alaska. I did in Hawaii, and that was nice. But
I'll bet.
Yeah.
Did you get to go there?
Yes.
Any stories that you picked up when you got there? Did you get a sense of the culture of that office?
They were young. People in that office were young. There was a lot of turnover. So branch chiefs, the assistant directors, those management positions would turn over. So it was a young office.
Okay.
And that was beneficial to me because I was able to progress up the career chain fairly quickly. I was a staff attorney for 2 years, a branch chief for 2 years, an assistant director for 2 years, and then I became associate director running the enforcement program for Los Angeles and San Francisco, and played also a coordinating role with the Seattle regional office at the time. So I was fortunate to be in an office where there was so much opportunity. We were assertive, we were young, we were excited. It was a really great staff, and it was a really positive experience for me.
You mentioned San Francisco,
Mm-hmm.
and at one time that had been the regional office. That had been the big show. What were the relationships like with the San Francisco, I guess it would have been the branch or the district office?
Yes, I don't remember if it was the branch or the district. It probably had both nomenclature during my time. It was a good relationship. We divided up the state into northern and southern, and it was a smaller enforcement staff than we had in Los Angeles, but I think we worked pretty well together. And also Seattle, we worked pretty well with the Seattle office as well. We were very much, our identity was, in my mind, it wasn't just we are the Los Angeles office, it's we are the region. We are the Pacific region. And so we helped each other and supported each other.
No territoriality, like, hey, this is our case, we want to handle this one?
Not that I remember. I do remember lots of territoriality with the New York regional office, as you probably, in your experience, talking to former SEC people, I'm sure you've heard about that. Los Angeles is 3 hours earlier, so we would get cases opened in the system early, and then we'd argue about it with the New York office or headquarters. Where was the nexus, appropriate nexus for the case? And I know there are standards and rules now at the Commission for which office investigates a particular matter, but at that time it was real competition. So if a public company was traded on the New York Stock Exchange, the New York office would say, well, we should be investigating this case. So, it was good-natured and it was friendly, but I think it's indicative of the fact that the enforcement staff was really aggressive, really assertive about wanting to tackle fraud. And so, yeah, it was all fun, though.
I want to touch on a couple of the highlights in that period. There's something called the Weimer fraud case that came up in my research that you were involved in. Can you tell me a little bit about that?
Sure. He was an investment advisor in Orange County, and the way that I got the case was a referral from the examiners in the Los Angeles office. They had done an examination, found indications of fraud. My recollection was that it was both investment advisor and broker-dealer examiners, so it would have been Stan Miyakawa, who was the assistant director for, assistant regional administrator for broker-dealer exams, and Mike Levitt, who was the assistant regional director for investment advisor exams. And so they referred the case to enforcement. I got it, and turned out he had diverted account statements that were meant to go directly from his clearing broker that he used to clients, and had stolen their money. And it was a lot of money at the time. It wouldn't be now, but it turned out in the end to be about $100 million. And I brought the case, and it was generated a lot of press. A number of municipalities had been defrauded, sadly. A big municipality in Iowa had lost a lot of money. So it was a real tragedy. We brought the case, as I recall, as a temporary restraining order, had a receiver appointed right away, who then went about doing the analysis of investors who had received prior returns that were, fraudulent, and figuring out, how to obtain disgorgement and eventually paying money back to investors. It was a really exciting case. As I recall, I was an assistant director, I think, when we brought it. I worked really closely with folks in Washington on it. Colleen Mahoney, who at the time was the chief counsel for the Division of Enforcement, was really helpful to me in figuring out strategy and how to go about bringing the case. I remember the day we brought the case, the phones were ringing with reporters, and it was mad. In the end, he went to jail. We obtained an order of disgorgement that was unique at the time. I don't know if the SEC's ever done it before, but rather than ordering what he would disgorge, we ordered what he would be allowed to keep, and everything else would be turned over to the government. And we were pretty tough on him. He was allowed to keep one suit, and just like we were very tough on him. He basically had to disgorge and give up everything. And he had acquired the fruits of the fraud. He had lived a lavish lifestyle, as they say. So in the end, I think justice was done. It was an exciting case.
Why did you come up with that settlement, that sort of turning everything backwards and deciding what he got to keep rather than what he had to give up?
It was easier. But you didn't have to inventory this car and that and this piece of art, and we just said everything because we had evidence that indicated that his entire lifestyle was funded by this fraud. So it seemed appropriate to craft an order that everything he had, even if we couldn't identify it at the time we entered the order, needed to go back to the government for restitution to victims.
Any other high-profile cases from that time?
Not high profile, but I was particularly interested in regulated entity cases. I brought soft dollar cases against investment advisors, suitability case against a registered rep, and then a failure to supervise case against the registered rep's employer, and I really enjoyed those cases. I really enjoyed the regulated entity cases. It gave me exposure to the Investment Advisors Act and the Investment Company Act, which I came to really enjoy. And it was relatively rare, I want to say, back in those days. Rick Marshall in New York was doing 40 Act cases, and Anita Nagler in Chicago did 40 Act cases, and I did 40 Act cases. So it was a bit of a niche, and it allowed me to, as I say, to learn about the 40 Acts, and also to meet people in Washington who helped me understand the law, people in the Division of Investment Management and the Division of, at the time, Market Regulation.
So a regulated entity, that's an investment advisor, is this gatekeepers and lawyers, things like that?
No, regulated entity in that parlance is registered broker-dealer, registered investment advisor,
okay.
Transfer agent, mutual fund.
Okay.
Yeah.
Yeah, that's the 40 Act.
Right.
Okay.
And the Exchange Act for broker-dealers. Yeah.
So you moved up to, at some point you became acting director, right?
I was acting director of the San Francisco office.
Right.
How
did that happen?
Well, I was the associate director in charge of enforcement in Los Angeles. The regional director of San Francisco left, and they asked me if I could split my time between San Francisco and Los Angeles. And that was really fun because I came into it, they didn't really know me. I had to make clear that, I was supportive of them. I had to make sure the morale was good. I really wanted to make sure that they continued to do the work that they were doing. It also gave me much more exposure to the exam program in San Francisco because I was responsible for it for the first time. And got to know the examiners there and their work. And that was really exciting. I didn't do it for very long. I think I was commuting back and forth from Los Angeles to San Francisco for about a year.
Okay. And in doing that, you're also, one of the things that the director has to do is sort of make sure the trains run, just operate the office. Where'd you get the insights and sort of the knowledge that you needed to do that?
Well, I relied on Jim Clarkson, who was the head of regional office operations. He was for administrative stuff, he really helped me quite a lot. I moved the office in that period in San Francisco. We moved from one location to another, and I was heavily involved in, what phone system should we buy? What should our desk chairs look like? Just like every minutia of the move. I mean, the thing about the SEC, certainly at that time, was it had very little support, administrative support. The people in charge were really in charge of everything, including the office move and what phone systems you have, as well as what types of enforcement cases are you going to bring? Do you have the evidence? What types of exams are you doing? All that stuff.
Right.
So one thing I would say in retrospect, I considered myself in my own head kind of a turnaround person. I was going to fly in and I was going to help make sure the office is running well, and the investigations and the exams are going well. And I did that in San Francisco, and I did it a little bit in Seattle too. So I thought of myself as kind of a turnaround person.
Is that how it worked out? Did somebody step in then?
Yeah, there was then a permanent regional director, district administrator appointed in San Francisco and in Seattle.
Yeah. It's interesting because so much of your career is in examinations and inspections, but at the beginning you were heavily involved in enforcement.
Yes.
And so it sounds like you started to get that examinations perspective fairly late in this early period.
Yes, I did.
Okay.
I did.
And what was your sense of how that was working out? The regions essentially, were an entity of their own, but then they had this split personality, the enforcement and inspections. Give me your sense of how that system worked then. Some of the insights you had about how it could have worked better or been improved.
Well, they were very separate, exams and enforcement, very separate, and enforcement attorneys had public profile, they were in court, they were in the press, examiners much, much lower profile. And it was really when enforcement attorneys received referrals from the examiners that I think they came, as I did, to really understand and appreciate what regulation, as it was called then, what they were about and what they could do. But even within the exam program, they were very separate too. There was the broker-dealer exam program and the investment advisor, investment company exam program. So really it was, and then there was a smaller bankruptcy program in many of the regional offices. So it was really quite fragmented. They came together at the top. The regional director, district administrator supervised both programs. But there wasn't a tremendous amount of interaction. We had, we made sure that we had regular picnics, office picnics, where regulation would play enforcement at softball. And I think it was pretty evenly matched, friendly rivalry. But they largely went about their activities and their function pretty separately.
Did examinations also do Reg A filings at that point?
Yes, they did. They did. I didn't have much exposure to that at all. Yeah.
At one point, that was a pretty big business.
Yeah.
But it might have been tapering off at that time.
Yes.
Anything else we should talk about having to do with your time in the Pacific region?
I don't think so. It was really through this Weimer case that I got to know people in Washington better, and in particular Chairman Levitt, and his then Chief of Staff Executive Assistant Colleen Mahoney recommended me to take over her role. And my recollection is I flew out from Los Angeles to Washington, D.C. on a Thursday and met with Chairman Levitt, and we hit it off. And he said, "Can you start on Monday?" And I said, "Yes, of course." So my recollection is my time in Los Angeles came to a close, pretty abruptly when that happened. But it was a very good office, very strong office, a lot of female attorneys, female accountants. I said that the office, that there was a fair amount of turnover, and that was in the attorney staff. The accounting staff were experienced and had a lot of experience and were long-term. So it was overall a very positive experience for me.
That's interesting. So the examinations and inspections people tended to stay.
Yeah.
Yes. Okay. Yeah, that's something I hadn't picked up on. When you met with Chairman Levitt, what did he talk about? Was there an agenda, or were you just going to come in and assist him with whatever?
I don't really remember that interview. It was kind of a blur, the actual interview. It was a very heady experience. The chairman of the SEC, for anyone who works at the SEC, but particularly somebody from a regional office who doesn't have ongoing exposure other than enforcement cases to the commission, meeting with the chairman was a big deal, really big deal. And with Chairman Levitt in particular, he was extremely activist. He had a lot of ideas. He was engaged. He was charming. He wanted to get things done. I think he wanted his second chief of staff, executive assistant, to also be somebody who had experience within the agency to help him navigate the different offices. He was relatively still new at that time. I think, a couple of years in to his tenure. So he was looking for somebody who knew the agency, who could help him navigate internally.
Did you bring some of your expertise that you developed and sort of influence what he was looking at? I mean, I guess the point here is you had looked at examinations, for example, and OC comes along fairly quickly after you come into headquarters. Were you talking about examinations and how regions could work better?
Oh my gosh, no. I helped the chairman with his kind of day-to-day, which is extraordinarily busy. He was active he had a big investor education push to meet with investors across the country with the local press and local congressmen and senators. He was very active in pay-to-play, Rule G37, auditor independence, the NASDAQ, the NASD market maker case was kind of coming to fruition then. We had market structure rules. He was testifying all the time. He was giving a lot of speeches. I was just helping him kind of organize this. He didn't need ideas he had a lot of ideas. I mean, remember, he came to the SEC, had been the chairman of the American Stock Exchange. He had a huge book of contacts. He knew people all over the industry, all over Washington. In 1994, it was the Republican Revolution, so Congress flipped from both houses became Republican. He was trying to navigate that. He was extraordinarily busy, charismatic, influential. So I just helped him kind of run the ship, keep everything, make sure he had what he needed in order to go out and do what he was doing. I didn't have anything to do with the idea to create OC. So I worked for Chairman Levitt for about a year, and he really influenced me. He was an activist like I naturally am. He was my mentor and deeply influential to me in my career. But it was the staff within the chairman's office who covered trading and markets who were critical of most inspections, stock exchange inspections for the most part, who came up with the idea to, well, there's two different inspection functions, one in investment management and one in trading and market regulation at the time. Why shouldn't we have a professional cadre of examiners? And shouldn't they be independent from these larger policy-making, rule-making divisions? So they came up with the idea, not me. I didn't even know about it.
These are people in trading and management?
No, this is in the chairman's office.
Okay.
The chairman had dedicated staff, Carrie Dwyer and Mark Tellini, responsible for looking at all of the market regulation issues.
Okay.
And so it was their idea that to strengthen the exam program, to reduce inconsistency between the different exam programs that existed at the time. There were lots of complaints about overlap and duplication, and different processes that the different functions used. And I think they wanted, they were looking at GAO as an independent inspection function. Lots of firms have internal audit that's independent, independent accounting functions, and they said, why don't we have our own independent inspection division. So the idea came from them. The Chairman Levitt had, as part of his stated mission, said he wanted to look at areas where the functions of the agency could be improved, including the organization of the commission. So a couple years earlier, he had changed the reporting structure for the regional directors so that they no longer reported directly to the chairman. They reported to the head of enforcement. And there were other organizational changes that he made. I think he considered this of that type. How can we strengthen and improve the way the commission operates and be responsive to some of the perceived weaknesses in prior inspections?
That goes along with what you've said about Chairman Levitt having all his own ideas and things. But let's double back. Were you there in the region when that reorganization happened and the regions suddenly reported directly to enforcement?
To the director of enforcement, I believe I was. I believe I was still in Los Angeles. I was not a regional director. I was the associate director for enforcement, so I didn't perceive that was a significant change for me.
Okay.
I think it was for some of the regional directors, particularly those who had been there for a long time, who were used to reporting directly to the chairman of the OCC, and now to report to the director of enforcement. Some of them, I'm sure, perceived it as a step down. Mm-hmm. But it was really meant to reduce the separateness, the separate regional offices doing their own thing. It was one enforcement division, and they later became one, when I was head of OCIE, one exam program. And that's all, in my view, that was all for the better, because it made us much stronger. We had a much louder voice when we were speaking as one agency program, Division of Enforcement or OCIE.
Right. So tell me how the OCIE thing rolled out. You've discussed this idea and the fact that it made good sense to put the inspection functions together. How was it developed? Was there a pilot program? Did a group get together and sort of flesh it all out?
Well, the idea for it, as I said, I wasn't involved in. Arthur came to me after he had decided to do it and said, would you do this? Would you start OCIE? And it had another name in the beginning, and the Office of Securities Industries Exams or something.
Right, which is also OCIE,
right,
with an S.
So he came to me and said, would you do it? And I remembered my time working with examiners, and I said yes, but only for 8 months. I would start it, and then I would move on to do something else. And he said, okay, you might change your mind, but okay. And I wasn't really interested in doing it on a long-term basis, because the exams were still perceived as a little bit sleepy, you know, in the agency. They had a very, very low profile. You know, at that time, it was individual exams of individual companies, and the exam staff would, at the end of the exam, send the firm a deficiency letter. And so the communication was very one-dimensional. It was from an exam team to a registrant. And there was little or no extrapolation of exam findings. You know, what are we finding more broadly? How are we looking at issues in a systematic way? It was very individual, firm by firm by firm. And I think that's the reason why it was relatively sleepy. You know, they weren't heard from within the agency, and certainly not outside the agency. So at first, that's why I was reluctant to say yes. I said yes for 8 months, which of course is, you know, it's funny to look back on now. I did it for 14 years.
Were the exams also generally on a periodic basis at that point?
Yes, exams. So there are exams and inspections. That nomenclature means nothing. We were responsible, OCIE and the exam program, the agency were responsible for conducting exams for compliance of investment advisors, investment companies, transfer agents, clearing agencies, broker-dealers, and the stock exchanges, and self-regulatory organizations. I believe I've remembered them all. But you know, that's a huge.
Yeah.
Those are a lot of very different types of entities. So, investment advisors and investment companies, the SEC was the sole regulator. For broker-dealers, obviously the SROs had the primary regulatory responsibility. So for investment advisors and investment companies at that time, there was an exam cycle no later than once every 5 years.
Okay.
And that was every registered entity once every 5 years. And at that time, the exams were pretty consistent. You know, there was a exam module that was big and long, and so no less often than once every 5 years, more frequently for cause. You know, if we had an indication of a fraud or a violation, we would immediately go in. That never changed, never changed. We always put gave cause exams priority. But for investment advisors, investment companies, once every 5 years. And broker-dealers, there were two types of exams. Oversight, where we would go in to evaluate the quality of the SRO's oversight of the broker-dealer, and then all other types of exams, cause exams, surveillance exams, we called it. But the routine frequency was performed by the SROs. And then for the SROs and the stock exchanges, there was also a frequency. I don't remember what it was now, but we would look at different parts of their activities. Their listing programs, their arbitration programs, surveillance program, disciplinary program, et cetera. And those exams would be done on some frequency.
Okay, so that was the system when you came in, right? What were the drawbacks? What did you hope to do to start to readjust things?
One of the first things I did, as I recall, it was within the first couple weeks that I took on the job, and I was alone, and we had a whole empty floor, the 9th floor of the office. The prior division had moved out, so it was me on day one, John Walsh, who came from the chairman's office, who became my chief counsel of OCIE, really important in the creation and development of OCIE, and my secretary and my human resources person. And we had an entire floor to ourselves. So it was lonely. But one of the first things we did is to create a mission statement for all exams. And the mission statement was, as I remember it, we are independent, we pull no punches, we call it as we see it, basically. We are going to be a tough but fair exam program in all types of exams. And I felt that was really important because I wanted to make sure the examiners knew that I would support them if they were going to make a tough call, that's what I expected, that we were going to write our reports straightforward. We weren't going to make it look pretty. We were going to call it, And I thought that was important to demonstrate right off the bat to examiners that whatever their past experience was within the other divisions, that this was new, that we were going to be tough, but fair.
How were things made to look pretty in the past? Just generally speaking.
Well, there was a perception that the examiners didn't call things. I wasn't there then, so I don't know. I do know the first year of OCIE, I had a couple of experiences with senior folks who had joined from another division. Remember, I had to deliver some really strong words to a particular firm, and I called them in to Washington, and I was ready to sit them down in the conference room and tell them with a lot of seriousness, you must change. These findings are serious, and I mean it, right? So, ready for that meeting. It's one of my first in that way. I did a lot of those types of meetings over the course of my 14 years, but I recall that was my first. The firm's senior management comes in along with a couple of my senior people, and they had just been out to lunch together. And they came in and they were smiling and laughing, and I thought, this is the wrong message. This is the wrong message. And I saw a couple of examples of things like that I just thought we needed to make sure that firms, the industry, were viewing us solely as inspectors. All we're here to do is to tell you where we've had problems with what you're doing and make recommendations for improvements.
Yeah, is part of the problem that inspectors, examiners go to the companies and spend time at the companies and get to know people and sort of start to identify?
I saw it with a couple of people, senior people, who had ongoing relationships with these entities. I never saw it with examiners. Examiners they really wanted to find fraud. They really wanted to do a good job. They wanted to feel empowered. They didn't want to feel like somebody in some other division could tell them not to, don't be so tough on this firm. That was anathema to them. To such an extent, and this is I think really important in my recollection of OCIE. Very, very frequently when we would be sitting down talking about, well, what do we do about this issue, or what do we do? What is our recommended solution going to be to this company to fix this problem, this violation that we found? Inevitably, someone would say, well, investors will best be protected by doing X. And it wasn't just assumed, it was spoken out loud. How are we best going to protect these investors who are doing business with this firm? And that was the way they decided, we decided what to do. It wasn't, what is so-and-so going to think about this? Or, is somebody going to complain to, people on the Hill? Or it was never that. It was always only about investor protection. So the exam staff were fantastic. They were really high caliber, and I think they would say that the creation of OCIE brought them this kind of ability to be single-minded. They didn't have to worry about policy or, a new rule coming or what so-and-so would think.
Right, and the exam staff themselves are working for different divisions.
They had been previously.
Yeah,
right. So bringing them together, the other thing on day one was seeing the inconsistencies in the two programs, and it's a normal, natural thing, right? I mean, they just grew up, differently. So different processes, different procedures, different documentation standards, different, one group had a policy that they would conclude exams within 60 days, and the other one had a completely different policy. And just from little things to big things, there were big inconsistencies, and not only between investment advisor, investment company exams and broker-dealer exams, but in each regional and district offices. Because they had, grown up on their own, they didn't have a lot of leadership or direction from Washington. It was normal that they had different practices. So day one began, for me, a 14-year process of driving consistency and driving consensus to the extent we could, and driving us to be one program. And John Walsh was incredibly helpful with that. The protocols, the policies, the procedures, the standards, all that stuff was an enormous amount of work to bring people together so it could really be one program.
Right. So that was your main intellectual task at that time, is trying to make that happen, I guess. The thing you were thinking about the most.
I was certainly thinking about it, but this is a time when the markets are really active. Like, there are a lot of different things happening. So I'm doing the management and the bringing of people together, but I'm also doing inspections. I believe I started at that time. We put out an inspection report on sales practices and supervision. I think that happened. We did that the first year of OCIE's creation. And then we initiated an exam sweep of soft dollars. I think that was in year 2. Brokers, advisors, mutual funds. And that was a way to say, okay, we're going to create one exam module, and different regions and districts, you're going to go out and use this exam module, and then we're going to pull together those findings into one coherent story about the state of compliance around this issue. So that was important, and it was important because it then set the standard for lots of other exam sweeps and exam initiatives where we were acting as one exam program.
Okay, so a sweep is essentially coming up with a plan and implementing it nationally.
Yes, nationally, or sometimes, like later, I asked individual offices to develop ideas for sweeps within their regions for issues that they thought were unique to their region. Okay, you guys in Atlanta go out and look at the sale of church bonds, as I recall, in Atlanta was an issue. And, so I asked them to do that, and they did it. They thought about what particular emerging compliance issues existed in their region, so they would do it regionally. But then there were other exam sweeps where we did them nationally, and it could be, a dozen firms, or it could be 200 firms. They ranged in size. But at the end of the day, what we wanted to do was to learn from that. It's the first time, really, that as a everyday part of our program, we were trying to learn about emerging issues and what the state of compliance with respect to those issues or those firms was. So sweeps, that was a tool to allow us to relatively quickly do that.
Something else that is discussed a lot early on is the idea of taking a risk-based approach. Talk about implementing that.
Sure. So that was in reaction to the very large exam modules that were being performed. In my memory, it was mostly investment advisors and investment companies. Big, long, kind of soup to nuts exam modules of every firm at least once every 5 years. And I thought, okay, all those issues may not be relevant to these individual firms. So let's allow examiners to risk target their work within a particular firm to those areas that there were indications were high risk. And in the very beginning, we called those SMART exams, which was a huge mistake, honestly. And I think it was probably my idea to call it SMART exams. And what I meant was be smart about how you're targeting it. And the industry loved it, SMART exams. That means, more targeted exams. But the staff did not like it, and I heard about it. What were we doing before? Were we doing dumb exams, Lori? Right. And so they were really insulted by the nomenclature. So we changed the nomenclature. I completely got it. We changed the nomenclature, and they became risk-targeted exams.
Okay. So you started up in 75, right? Or I'm sorry, 95.
Yes.
How long was it before you felt like OCIE was really kind of up and running? Obviously there was a period where you're breaking in, you're doing a lot of hiring or bringing people in. How long was it before you felt like OCIE was really standing on its own 2 feet?
I felt we were standing on our own 2 feet right from the beginning.
Really?
I mean, yeah, because here I am in this empty floor, and then people started to come and populate the floor, and we were still doing exams. It's not like everybody was paused waiting for this,
right,
new organization to come together. We were doing things right away. We were still doing, obviously, all the inspection work. I feel like we got better and better and better over time. I believed in constant improvement. I believe that was part of the mission statement. I believe that we should always be looking for ways we can improve. We're never going to be done. That was really important to me, and I believe the entire time, that I was in OCIE, I think we tried to do that. We really tried to do that. So I never felt like, oh, this is it. We've reached the perfect nirvana of this organization.
Always a work under construction.
Right.
Yeah.
Right, or improvement, always constant improvement. And I often thought, because I was there for 14 years, I often thought, how would somebody else sitting in my chair do this? How would someone else, react to this issue? Or how would they handle this issue? Because I didn't think I always had all the perspective. I really wanted other people's perspectives.
So after the end of the 8 months anyway, did you sit and say, well, gee, I guess, I guess maybe I'll move on, but maybe I won't? Was it tough to decide? Or?
No, it was fun, because it was fun. Remember, I had considered myself kind of a turnaround person, so I felt like this was a real startup, and it was fun. And I want to say it was within the first year, I gave a terrible speech, my first speech. I was really nervous. I was not a natural public speaker at all, and it was a terrible speech, and I got really bad reviews. The comments at the end, really terrible reviews. And I was a little daunted by that. Like, could I do this? Could I be the voice, the face of this program? Could I do that? And that, I took that as a personal challenge. And then I was talking to a reporter. Reporters were very interested in this new thing. And the industry was really interested in it. I remember there was some skepticism of me at the time because I came from enforcement. And so some of the trade groups in particular thought, oh, she's an enforcement person, she's a hammer, the nail is the enforcement case. She will just want everything, all the exams to go to enforcement. So they were nervous about me. And I knew that at the time. And some of my staff, they didn't know me. They didn't know who I was. They didn't know what I was about. And they wondered if this enforcement mindset would change what they do. So I found that to be something that made me want to stay and keep going. And then also I was talking to a reporter. As I said, the press, there was a lot of interest in this from the press, and the reporter asked me, what keeps you up at night? And I said, suitability in sales practices, broker-dealer sales practices, it really worries me, Suitability cases were notoriously hard to prove. It was always he said, she said. And so that was what worried me. And the next day, there was an article in the business section of the New York Times. Lori Richards says, this is what keeps her up at night. And I thought, oh my gosh, I can use this. I can use this role. People care. And by the way, firms went out and looked at their suitability, sales practice, compliance, and supervisory programs after I said that. They went out and looked at their own programs. And I realized the power from a public policy perspective of what this program could be. If a reporter cared about what kept me up at night, we can really go somewhere with this. So,
and what kind of levers you had to deal with personally too? Just by saying these things, you could get something accomplished.
Yes, but more than that, I could start to use this otherwise quiet function and what they were finding and what they were doing, and we could talk about that. We could get the word out about what issues we cared about, what we were going to be focusing on in the next year's exams. That became something very routine for us to say, here are the top 10 issues we care about. And what the findings were of our existing exams. That became the basis for a lot of public reports and speeches, et cetera.
Okay. Let's disperse with the old chestnut at this point, which is that you can't break exams and enforcement apart because the enforcement people learn from the exam people, and so they need to be in the same room or under the same boss? Because there was a lot of that. I mean, there were people who felt that, you know, it was not good to move all the exams and inspections over here. What was your answer to that?
I think the people who may have said that were not the examiners themselves. Because examiners themselves, the feedback I was getting, felt empowered by this. They were now their own function. Examiners sometimes felt overshadowed by enforcement for the reasons I've said. You know, they were more colorful, they're in the press, they get all the glory, bring the enforcement cases to the commission for approval, and examiners were much sleepier, or were perceived that way. So I don't think that the examiners felt that. I think some of the senior people, regional administrators, may have felt that here's another country heard from, here's another, you know, now this OC director is going to be my boss. So I think there was probably some of that at the beginning. I think that went away pretty quickly because there's a big difference between the tools that enforcement uses and the tools that examiners use and their function. Very different.
So you didn't find that to be a big hurdle in any way, I guess?
No, I didn't.
Okay. Let's sort of talk thematically about some of the things you dealt with. One of the things I have here is research analysts around 2002. There were some conflict of interest cases you worked on.
Yes. So thematically, if I could, I worked on a lot of, a number of crises type issues, and research analyst was certainly one of those. In the very beginning, I think this was at the end of Chairman Levitt's tenure, we noticed that there were star analysts, you know, the Jack Grubmans of the world. They were everywhere on CNBC. They were getting a lot of press. They were, it was unlike the research analysts of the past. And so we noticed that, and we wondered why, you know, why? And we thought, well, maybe research analysts, maybe they own stock in the companies that they're touting. And we perceived that they were touting, you know, companies. So we wondered about that. So we did a series of exams to look at that, whether individual research analysts stood to benefit from the companies that where they were issuing research. You know, really fundamental conflict of interest. And then, so that kind of got us into the world of research analysts. And then my recollection is that enforcement, along with the New York Attorney General, became interested in research analysts and the various conflicts of interest that could exist. And we didn't really understand at that point. So I launched along with Steve Cutler, and eventually including FINRA, the New York Stock Exchange, the Attorney General, and NASA, a fairly large series of exams looking at the structure of research within the big firms. How were research analysts compensated? What were their relationships with investment bankers whose only job really is to bring in potential new business? What about independent research? Why wasn't independent research more valued? All the kind of structural issues. So we divided up the world, big firms, between all these different regulators. We kicked it off. We met in Washington and kicked it off, and then went out and did these exams and reviews, and came back. I don't know how long it took. It took a while. I don't remember how long it was, but came back and compiled our findings and our observations. Enforcement was right along with us. We were working very closely together. This was very much a joint collaborative effort. Steve Cutler and I worked really closely together. And then Steve really led the negotiations with the firms about settling. And it was extremely complicated because of all the firms and all these different regulators who were involved.
So you did find what the kind of thing that you were concerned that you might find.
Yes, and it's a story of a lot of my time at the SEC, that conflicts of interest are what breeds problems. When someone has an incentive to favor themselves, or in this case, research analysts wanted to curry favor with investment bankers who had a role in determining their compensation. Those conflicts of interest can corrupt processes, and I saw that over and over and over and over in my time at the SEC. So two thematic issues that I think come from research analysts, or maybe three, research analysts, and then later the other big initiatives that we undertook, often with the Division of Enforcement and other regulators, are conflicts of interest. Email will tell you the truth about what's really happening, what people are really thinking. You know, you can have all of the policies, procedures, whatever, but it's the internal email where people are talking to each other, where you can see what they're thinking and how they're feeling. And in my recollection, this was one of the first cases where it was the emails that really told the story and made it kind of irrefutable. You know, when we went to talk to the firms about settling, made it irrefutable what was happening. So that's the second thematic thing. And then the third one is the power of working collectively with other regulators. And it was not easy, certainly. But at the end of the day, and Steve really crafted so much of that settlement, so much of the proactive, the forward-looking relief really came from Steve Cutler. And at the end of the day, all of the regulators signed off on it and implemented it together, and we had the power of, you know, New York Stock Exchange, NASD, NASA, Attorney General, SEC. And that was a real success, I thought.
What were the challenges of working with the other regulators? Did they naturally have other concerns, or were there personalities, or was it just too many cooks?
There are a lot of cooks, and there's a lot of personalities. I mean, everybody, we were in the press all the time, right? There was a lot of focus and scrutiny on regulators. And so everybody, eventually we locked arms and, you know, let's do this, let's get this done together. So everybody had to compromise in some way. The firms certainly did, and we certainly did. And I think at the end of the day, everybody looked at the relief, which really was fairly unique. It implemented structural reforms, separation of functions, compensation changes. Independent research had to be provided to the firm's clients so that they could look at the independent research and the firm's own research and be able to evaluate. And that was pretty unique in terms of SEC settlements. And I think that really helped people come on board, helped regulators come on board. This is good, not just looking backwards, but it's going to be good for the industry looking forwards.
And this is a global settlement, so everyone has to sign on.
Yeah. It took a while. I mean, it wasn't overnight. It took a while to negotiate.
And I assume there was some rulemaking that followed that in the commission?
We always thought, we always thought that there would eventually, the reforms that were implemented in the global settlement would result in commission rules. It didn't. I think there were SRO rules, there were New York Stock Exchange, NASD rules, if I recall, but the global settlement didn't sunset. It I believe, continues.
Okay. Well, we talked about analysts. You mentioned earlier that you were particularly interested in mutual funds, advisors, that kind of thing. And the next big thing you get is the late trading and market timing with the mutual funds.
Yes.
Let's run through that a little bit.
That was pretty soon after research analysts. And by the way, in between here, there's a lot of other things happening. There were a lot of other things happening, which I'm happy to share with you, the most memorable ones for me. But so my recollection is that there was a tip or complaint, a whistleblower that approached the New York Attorney General, Attorney General Spitzer, and he announced that this was an issue. And I think both Steve Cutler and I at the same time went, oh boy, here we go, here's another one. We don't know how big this is. We don't know if this is limited to the firm where the whistleblower complained about, or if this is more widespread. And I got my staff together, my exam staff in Washington, and I said, we got to find out. We have to find out how big this is. And we need to go big. We need to go big. We're not going 5 firms here, 5 firms there. We're doing this big. We're going to send out document requests, exam requests to, I don't remember, it was like 100 and some firms. And I remember somebody on my staff saying, "We can't. This is too big. We can't manage this." And I said, "Oh, yes, we can. Yes, we can. I have confidence in us." And then somebody else said, "Yeah, but do we really want to know the answer? What if it's really big, and then we're going to have to say we found this and it's really big?" I said, "Yeah, that's what we got to do. We have to find out." So we launched this, and we did find that there were other indications, other examples of market trading, late trading. I don't remember the percentage, but it was a significant percentage of the firms that we had communicated with. And we said so. We said so. We told Congress, we told everybody, this is what's happened. And that ultimately resulted in a lot of enforcement cases against firms for allowing market timing and late trading. Also conflict of interest, because they were favoring certain investors over others. So that, again, the conflict of interest. Also emails. There were also emails that were involved there. But that market timing and late trading resulted in rulemaking that I was really pleased with. I mean, the rulemaking came pretty quickly after the understanding of the problem. That's the way I always thought rulemaking should happen. It's hard to do rulemaking before you know what the problem is, but hopefully you have rulemaking pretty quickly after you identify the problem, and I was really pleased with that. Investment management, Paul Roy, and I worked really well together.
So this was the compliance rule?
Well, there were a lot of other rules around market timing and late trading that were specific to that conduct. But yes, the compliance rule was so important to our program and to the industry. And that was Chairman Pitt advocated for it because, remember at this time, in 2002, the industry grew exponentially and outstripped our ability to examine every firm at least every 5 years. We lost that ability. The industry grew so big, so fast. So we had to switch to a completely risk-based program, which was deeply scary to me, really, because what were we not able to see? So thinking about how can we encourage advisors and funds to human up their own compliance programs to a greater degree? The compliance rule, for the first time, it required funds and advisors to have written policies and procedures around compliance. Before that, they didn't need written policies and procedures.
They just complied.
That's what they said. We just know what to do, and that's what we do. And do we have evidence of it? No, we don't have evidence of it. So, just crazy stuff. So it really, I think, professionalized compliance in a way that it needed to become professionalized, required every firm to have a designated chief compliance officer who performed reviews at least annually, wrote a written report on the state of their compliance program to senior management. It did a lot of good things. And so then we were later able to use that to really push the chief compliance officers and the compliance function to become more professional, to be fully resourced, not for firms not to cut compliance staffs. That was a big message that we communicated, particularly during the financial crisis when firms were looking to cut expenses. So that was, in my view, one of the most significant rules in my compliance world that the Commission ever adopted.
Was that a tough rule to put together?
No.
It was clear what had to be done.
Well, I wasn't the rule maker. It was the Division of Investment Management. But these things, a designated chief compliance officer, policies and procedures, annual reviews, forensic testing, those are the elements of any good compliance program. Okay. So I didn't see it as controversial. I'm sure that there were pieces in the original formulation that investment management was working on that maybe were, but in my mind, it was pretty straightforward.
And sort of predating this, there were some enforcement actions against SROs, New York Stock Exchange included.
Yes.
Let's run through that a little bit.
Sure. So I had a really good inspection staff for trading, market making, arbitration, listings. I had a really good staff, and they were mostly in Washington. And I had a lot of confidence in them, and they proved that it was worthy. One of the first big inspections that I remember was of the New York Stock Exchange, and it found pretty pervasive violations by exchange specialists, trading ahead, I think proprietary trading, and a very lax surveillance and disciplinary program on top. And we wrote a very, very strong report, an inspection report, non-public inspection reports go to the SRO and generally to their boards of directors and require improvements. And this was a very significant report. New York Stock Exchange, huge. And we had used, I think it was one of the first times, we used the Office of Economic Analysis to look at the data and identify the violations and quantify the amount that was gained or lost. So it made our reports much, much more powerful. It wasn't just, oh, we observe. It was, no, here is the data that indicates the violations and the dollar amount that was lost or gained. So that report was filled with that kind of data. We sent it to the commission, and the commissioners were alarmed, upset. This is a terrible thing. And as I said, our reports are non-public. I happened to be at a course on regulatory and enforcement agencies, how to run a regulatory and enforcement program at Harvard's Kennedy School for a week, I think. And I opened the newspaper, Wall Street Journal or New York Times, and there was the inspection report, basically a huge story about this inspection report that had just the previous week been sent to the New York Stock Exchange non-public. And I mean, I'm still stunned by this because they had the report. It was clear they had the report. I actually, because there had been some incidents of leaks of our reports in the past, so what I would do before we finalized a report to send to the commission for their approval, they reviewed and approved our SRO inspection reports. I would put like some number on the back. I'd just make up a number and put it on the last page. And when the reporters would call me, I'd say, well, I don't know if what you have is real. I don't know if it's really the report. Is there a number on the back page? And they would, so in this case, the reporter gave me that number, and I said, oh my gosh, it is the report. It's the report. So someone had leaked it to the press, which was a big deal, a really big deal. So got a lot of attention. New York Stock Exchange was obviously very upset. I was upset. No one knew who did it. There was an Inspector General investigation subsequently, never revealed who sent it, so I don't know. But a lot of drama in that report. It ultimately resulted in an enforcement case against the exchange for failing to surveil and discipline, and against a number of specialists and specialist firms for engaging in the violations. And that was another tool that we used. So when you're looking at an exchange, the exchange is responsible for surveilling and disciplining its members. We would look both at the exchange and at the members, so we could put the two pieces together. And it made for a much more compelling inspection, because we had, the weaknesses by the specialists and the violations, and then we had the weaknesses from the exchange perspective. So that was something new that we did, and we subsequently did it in a number of SRO inspections. So my recollection is New York Stock Exchange was one of the first inspections for trading ahead, failure to honor customer limit orders, proprietary trading. But then we examined all of the other exchanges and the options exchanges. Ultimately, many enforcement cases against SROs followed. And I like to think that the data analysis really helped the exchanges in the end, because they then could improve their own surveillance, their own discipline, tighten their time parameters for surveillance. And it resulted in a lot of improvements, but it broke a lot of eggs too. It was hard work, and it's hard to sue a stock exchange.
Yeah.
A fellow regulator in some ways.
This case, when the non-public report came out, would that have been in the late 90s or in the 2000s?
No, I think it was 2002.
Okay. And there was
2003.
a trading ahead case that kind of hit the headlines in 2005, that period. And another thing that's happening is that a friendly congressman is looking to get rid of OCIE.
Yes, that was a big surprise. There was legislation introduced. Was that 2003? 2003 was our report.
Okay.
And I shouldn't always say I mean, really, I had fantastic inspectors who worked on this. John McCarthy, Eric Swanson, Dor Meehan. 2003 was the leak of the report. 2004 was the enforcement case, I believe. The legislation was introduced by a Staten Island congressman, and it was basically eliminate OCIE, put OCIE back where it came from in the divisions, the Division of Trading and Markets and the Division of Investment Management. And I couldn't believe it that somebody cared that much about this, that they introduced legislation. So I remember John Walsh, my chief counsel of OCIE, and I went to visit the congressman to try to understand what the thought was. We didn't meet with him, we met with his staff, and came away with really no idea what the basis for this was. So I think it was reintroduced a couple of times, and then it eventually died. But I mean, I would be asked about it when I was out, talking to the industry or giving speeches or participating on panels. I would often be asked about what I thought of this legislation. I had to have no comment.
He didn't tap into a groundswell on the Hill or anything about OCIE.
No, no, thankfully.
Okay. And another thing I've got on my list here is credit rating agencies. You did a pretty substantial report about that.
Yes, this was our last public report. I have a copy because it was the last one. And I think we did at least a dozen public inspection reports. So this is one of many. But this was the last one, and it was really important because it followed the meltdown of mortgage-backed security, residential mortgage-backed securities in 2006, 2007. People wanted to know why these securities that had previously been rated AAA, why they were suddenly being downgraded in mass. Why? What was wrong with the original rating? What were the assumptions that were made at the time of the original rating that no longer proved to be true at the time of these downgrades? And we didn't know. We didn't know. We didn't have actually inspection authority over the rating agencies at this time. I don't think that came till later. I think we initiated the inspections before we had the authority, but we wanted to know why. It was, meltdown. The financial industry is in a lot of turmoil. What the heck was going on with these rating agencies? So we commenced exams right away. I think it was like the day before Labor Day, and we said you have 7 days or something to produce records. Over Labor Day weekend, and eventually we examined Fitch and S&P and Fitch, S&P. Come on. I'll remember it by the time we end. The 3 biggest rating agencies. Okay. And what we did was consistent with what we had done in the past. We went in and looked at the organizational structure. How were the analysts who are responsible for rating, how were they compensated? Who did they communicate with? What were their methodologies? Were there standards? And email. And what we found was that, again, conflict of interest. The volume of business exploded, and this was the model that existed then. I believe it still exists today, the issuer pays model. So if you're issuing a residential mortgage-backed security, you choose your rating agency, and you pay the rating agency to rate that particular instrument. So what we found was that that model had inherent conflicts of interest. Issuers would be incentivized to go to the particular rating agency where they felt they had the best likelihood of being rated AAA. And the volume of work that the analysts were getting indicated that they couldn't keep up. They just couldn't keep up with the work. They sometimes didn't follow their own methodologies. They didn't document when they didn't follow their methodologies. And as I said, again, email, lots of good emails where analysts were communicating, we'll rate it, even a cow would rate it, or like crazy internal emails that showed how much pressure the analysts themselves were under, and how they could deviate from their existing standards. So put that report out. Again, it was a public report. Great work by the inspection staff, really great work. I mean, they were incredibly dedicated day and night. They never gave up. The review of emails is not easy. It's very time consuming, very labor intensive. And I was just really, really proud of their work. It helped explain a lot of what happened with the rating agencies during that period.
How long did it take you to get the report out?
The report came out in July of 2008, so if we started in 2007, in the fall of 2007, for that volume of work and that analysis, and remember our reports, they weren't just my reports. I sweated every comma, right, in every report that we ever put out. Anybody will tell you that I spent a lot of time with the reports, but it certainly wasn't just me. The staff in OCIE, staff in the General Counsel's office read all of our reports in each of the divisions, and this was with the office, also the Office of Economic Analysis helped us a lot here looking at the methodologies, as well as the chairman's office and the chairman's office staff and all of the commissioners and their staff. So a lot of eyes on all these documents before they're released. And not just eyes on, a lot of commentary. And people have different views and different perspectives. And I wanted that because I wanted the final product that went out to be one where nobody in the building could say, I didn't know about that. I don't know what the heck they're doing in OC. I never wanted that. So I was always trying to be quite transparent, even though it was very difficult to get all these different comments back and sometimes objections.
It would have come out at a pretty good time too, because things were still, they hadn't quite exploded yet in mid-2008, right?
It was a good time. We had a press conference, Chairman Cox and Trading and Markets, Economic Analysis, and myself, and yeah, I felt very good about like kind of revealing that, that this was happening within the rating agencies.
Any other important
Moody's.
Yeah, there you go. Any other important sweeps or reports of this nature, sort of landmarks of your time?
I was really concerned about the relationship between brokers and mutual funds, the brokers who sell particular mutual funds. Why do they sell these funds? Why do these particular funds get top shelf treatment? I knew when I went to see a financial advisor for the first time that financial advisor seemed to prioritize particular funds, and sometimes not funds that were performed particularly well. And so why? So we did, I want to say 2 or 3 different exam sweeps of that issue to find out why. We did an exam sweep of brokers. Why are you prioritizing these particular funds for sale to retail investors? And then we looked at the funds. Why? What are you paying? Payments for shelf space is what it was called. Mm-hmm. So brokers were saying, wow, the mutual fund industry has really exploded. We want a cut of the action. We want to be paid more. And mutual funds, they want to be sold. So they want that top shelf treatment. So they were finding ways to compensate brokers that were not disclosed, including by the use of brokerage commissions, soft dollars. They were basically paying more in brokerage commissions to have their trades executed in order to compensate the broker for giving top shelf treatment. That really bothered me because it was undisclosed conflict of interest affecting everyday retail investors. So I think we went at that like over a couple of years in different ways so we could get traction. Ultimately, the commission adopted a rule that prohibited funds and advisors from using brokerage commission to pay for shelf space, pay these marketing expenses. So that was a big one. I felt really good about that and how that came out. We did a big report on pension consultants and, again, conflicts of interest and emails. The relationship is kind of the same thing. Pension consultants provide advice to institutional investors about which money managers to use. Pension consultants were also selling products to money managers. Inherent conflict of interest, not disclosed. That was important, I felt, because we also spent time with the Department of Labor on that, because these pension consultants were fiduciaries, but that seemed to be really inconsistent with their fiduciary obligations. So we coordinated and worked quite closely with the Department of Labor. I thought that was an important one. And I cared about that one because I had done the soft dollar case when I was in Los Angeles, and I learned a little bit about the relationship between pension consultants and the industry. So that Gene Golke, who's my associate director, that also was something that resonated with him too. So that was important. There were a lot of really important ones, but those are the ones that stand out for me.
Okay. And you mentioned Gene Golke. Who were some of the other people that you relied on through the years in OC?
In Washington, Mary Ann Gagella, John Walsh, absolutely. John Walsh, absolutely. It was hugely important to OC and to the program. John McCarthy, who ran the SRO inspection program. Helena McGee, who oversaw parts of the SRO oversight, arbitration, listing, the non-trading aspects. I was lucky to have a really, really, really good staff. And Dormian, who did the rating agency report.
Okay. In the middle of all this, you talked about, well, these were the big things, but there were a lot of other things you were doing in between all those big things. Did those change over time? The nature of your day-to-day during your 14 years or however long it was there some sort of transition in the kinds of things that OC was facing, or was it always the same? Conflict of interest, that sort of thing?
It was the same. I mean, sometimes the facts, the nature of the facts changed. Conflicts were always, there's a huge bucket of exams where the violations are not driven by a conflict. They're unintentional, they're mistakes, they're errors. That we dealt with, I think, in the right way. We sent deficiency letters saying correct this problem and make sure your systems don't allow it to happen again. But the real serious stuff is what is derived fundamentally from a conflict of interest, and that affects a lot of investors and can involve a lot of money. And so those are the serious ones. We made enforcement referrals throughout this period where we found fraud. The percentage of enforcement referrals stayed roughly the same. I think it was between 7 and 10% of exams in the investment advisor, investment company area. Maybe a little larger in the broker-dealer area because we were able to target any firm we wanted because the SROs had the primary oversight. So that stayed the same. Through all this, there was 9/11. There was Y2K. These are all things that were super important at the time. We were revising our exam modules all the time. We were doing risk assessment. We needed to have a better risk assessment program after we were no longer able to have this routine cycle. We needed to find a better way to risk assess the entire industry. So we started a program. I had 2 or 3 people do it full time, and they went out to examiners and asked them, what are you from what you see and what you hear, what are the top risks that you're concerned about? Say what those are and then rate them, in your view, what is the most risky, 1 to 10 or whatever. And then we compiled all of that data, and then we added to it, what are we seeing in our enforcement referrals? What are we seeing in enforcement cases that are brought? I don't remember, there were other inputs. And anyway, we came up with a huge kind of map of risks. And the risks were sometimes different within each region, But overall, we had kind of a view of what the risks are, and so then we used that to target and to set our goals. Each year we had a goals memo that told examiners what we were going to focus on for the coming year. So that's pretty rudimentary risk assessment. We pretty quickly realized we didn't have the data necessary to couple that examiner insight with actual registrant data. And that was a real weakness. That was really a big deal. So we didn't, for example, we didn't know who a fund or advisor's auditor was, or their custodian. Kind of pretty basic information that would have allowed us to better target those entities with, kind of rinky-dink service providers. So this was a mission that we were on for many years to get better data. We didn't have data about hedge funds. So hedge funds would just kind of, this was before they were regulated, before their advisors were registered, they just blow up. And we'd read about it. It just blew up. And we would say, we need a better way to see who's at risk. Because not only does that hedge fund blow up the hedge fund and the hedge fund investors, but it can blow up the clearing firm. And it can have ripple effects, long-term capital management. So this was a huge frustration for us, this lack of data. And we subscribed to services that would provide us with information about hedge fund returns, so we could see those hedge funds that were outperforming. But that data was voluntarily reported to those private services, so question the integrity. So we did a lot of things. I would talk to people, I'd call everybody I knew, what are you worried about? What's the issue? What's happening? What's around the corner? And Steve Cutler taught me about how to do that. He was really, really good at that. But our risk assessment was pretty basic. And I did as much as I could internally inside the SEC to say, wow, we need to have early warning systems on hedge funds. Why don't, as they get close to having a margin call, why don't we require the clearing firms to tell us, who's in that situation? Why don't we require mutual funds to submit better data, so that we can risk assess performance? Money market funds. I mean, we didn't have some kind of basic information on money market performance, so we couldn't see the aberrations on an industry-wide basis. We couldn't see the aberrations to know who might have been cutting it too close to the 2A7, bucket. So that was a really persistent complaint, and I felt like I was always, banging the drum about getting better data. I gave a speech about mutual fund data, and I put out the call, we need better data, and I felt like I made a good case, but the industry said no. And ultimately, after Madoff, we did get better data on identity of custodians and accountants, et cetera, but it wasn't, in my view, it didn't come soon enough.
Yeah. So I'm trying to understand this a little bit. The sense is you knew pretty quickly where the risks were, or what kind of risks there were out there. But you needed to find markers. You needed to have markers that would tell you that that risk exists in this particular location.
Yeah.
Is that what you were looking
Absolutely.
for?
Everybody said, just for example, valuation of investment advisor mutual fund holdings. Valuation, huge issue. It can be subjective, but how do we know? How do we know? We don't even have performance data that would show. So yes, exactly. And then that made it much more difficult to target firms based on those particular risks.
Okay. Winding down toward the end, let's see. I see here that Bill Donaldson provided a good bit of extra funding for OC when he was chairman. Where did that extra funding go? What were
Where
your
did it go?
priorities?
So first, Chairman Donaldson was wonderful to work for. He was the one that would say, look over the hill and around the corner, always be looking ahead for the next risk. I completely internalized that. And he also said, pull up your socks and just get it done. That I completely internalized those things, so he was wonderful. We got, over the years, 14 years that I was in OC, resources, and then there'd be a freeze, and they'd be reduced. So we got resources, and then there'd be a freeze. And we never were able to, as an agency, to be able to say, okay, there are just investment advisors. There are 14,000 investment advisors. So to examine those firms every X, whatever period, we need X number of examiners. It was never looked at that way. It was always looked at as, well, you have 425, I can give you another 10. But that gap was never used as, to make budget decisions. And I know it was because that gap was so big that you would be asking for many, many hundreds of people. And that was not palatable. That was not palatable during this period. So it was always incremental, given and taken away, given and taken away. And the way that we always staffed it with we always put the resources to the best use. So investment advisor, investment company exams often got the bulk of it because we didn't have the SRO for investment advisors who could pick up the slack. And it went to the regions and districts that had the greatest growth in the number of investment advisors. Internally we used that methodology, but externally we didn't. So I was very frustrated about this. This is probably my biggest frustration, because examiners bore the risk of this lack of resources. We bore the risk, and that's not the way you'd want to see the operation work. So I started creating metrics to send to the Hill. We would report periodically. I started sending metrics that would compare the exam frequency for advisors and broker-dealers. Because I thought, okay, come on, you can see this. You can see that broker-dealers are inspected much more frequently, and why don't you say what the heck's going on over here with investment advisors and investment companies? So, but it never really happened. The agency never got the full funding that it really needed to have strong programs. And the sad thing about that is that the public expected that examiners would be in there looking more regularly than we were able to. The public expected that, and there was a gap between their expectations and what we could do.
Right. Which was revealed in 2008.
It was actually revealed, many times.
Yeah.
Honestly.
I was trying to get to things that changed over time. And one thing that changed over time is you did get chief compliance officers in all the organizations. Talk about working with them and how you developed the CC outreach program.
CCO outreach, yes.
Yeah.
I don't know if it was my idea. It might have been Gene Golke's idea, but it was a way to have additional compliance resources. SEC can't do it all. Let's empower. Let's be the chief compliance officers' allies. Let's help them. So it was fantastic. I was really proud of the program because it was really popular. People came. We had big sessions in Washington, D.C., and then ultimately in all of the regional and district offices. And then even after that, we took CCO outreach on the road. There are a large number of non-U.S. SEC registered investment advisors. So we would go internationally and do these programs. And what we were doing was helping them feel that they were part of a professional cadre, new cadre of CCOs. They would hopefully have relationships with each other, share information amongst each other, and we would share information with them. So one of the first CCO outreach programs, we put together a summary of the kinds of forensic testing that we did, that examiners did on exams, and gave it out because we wanted them to use these same techniques and to develop their own techniques. And that was a little controversial because people thought we were revealing the secret sauce, but it wasn't. It was a really good thing. And we did regional seminars. Anyway, we did all kinds of outreach. And then we started issuing risk alerts, which I was very proud of. They were called compliance alerts. And they weren't inspection reports or exam reports. They were just summaries of things that we had seen and we were worried about. So it was much more of a, informal narrative about a bunch of different compliance issues. And I was very proud of those because it, again, allowed us to communicate with the industry in a direct way, which I thought was only going to improve compliance.
It is interesting in a way you're kind of you've created a new profession out there, this chief compliance officer thing. And and are trying to nurture it.
Yes, absolutely, and that's what John Walsh used to say. This is a profession now. This isn't just like your side job. You know, we had firms where the chief of marketing was also the chief compliance officer. This is your profession, and it has standards, and it has policies, and it has, you know, there's protocol. There's a community of people who do this work. And yes, absolutely. And now, I mean, I think it's been a real success. I know a lot of chief compliance officers, and they really valued what we told them, you know, how we advised them, and how we treated them as allies.
Now, throughout this whole period, IT is becoming increasingly more powerful. Did that make a difference? Were you able to crunch numbers in the late 2000s that you couldn't crunch in the mid 1990s?
Oh, absolutely. It became a very important part of our program. In all of our inspections, so I talked about SRO inspections, being able to see the data there, but we also used forensic testing in investment advisor, investment company, and broker-dealer exams, and developed some standard protocols for what that should look like. Churning. You know, we developed some standard protocols about what level of turnover was indicative of churning, and then we used those in every exam where we looked at churning. We were using the same methodology, and that was really important. Again, consistency, and we're one program.
Okay. So, 2008, the Madoff thing comes up. Do you remember where you were and what you were doing when you heard about it?
December 11th, I think, or 12th. It was early in the morning, and I got an email saying, from the head of the New York regional office, saying Bernie Madoff had just confessed. And I was like, what? And we had examiners in that morning, examiners from our New York office. I mean, this is what they did. Particularly in New York, you know, all the boiler rooms and the, you know, fraudulent operations up there, they were used to just get in there right away. So they did. And then I had reports every couple of hours about what was happening, what they were seeing, what they were finding. And within a couple of, I don't know how long it was actually, the lead examiner said, there's nothing here, there's no trading, there's nothing. And we had suspected for a while that he was front running and trading ahead, and you know, that there were violations in the broker-dealer. But the investment advisor, we had never examined before. It was only registered in 2006, I believe, and we had never examined it. And that's where the fraud was in the investment advisor. So they came back and they said, there's nothing here, and that was incredibly shocking and upsetting. And obviously he stole a lot of money, but he had also lied for so long about the returns that he was generating. So investors believed that their investments were worth far in excess of what they were. So it was terrible, most terrible for investors, but also extremely challenging for the SEC.
How did that translate over the next few days, weeks, months?
Well, I had to testify right away. Congress was alarmed, as they should have been, so I was asked to testify. My colleagues, other SEC division directors, were asked to testify too. So I think we testified first before the Senate and then before the House. And then the revelations came out. I didn't know that there had been a whistleblower complaint or a letter. I wasn't personally involved in it, so I was learning about it as the public was learning about it. And that was disconcerting. So I felt it was important to take responsibility. You know, I was in the chair, I was the director of OCIE. Linda Thompson, my colleague, director of enforcement, we both felt the same way. We need to not duck, we need to say what we know and talk about this, and this is deeply upsetting for us personally, but we need to stand up and talk about it. And we did, and I felt good about that. I felt talked about the examiners and the exam program and how committed they are to finding fraud and how devastating this was for all of us. And then really quickly, we started to think about, well, putting together the dots, what happened here and what needs to change so that we can detect stuff like this and, more importantly, deter it in the first place. So that it was a lot of brainstorming sessions with FINRA examiners, just trying to figure out what we could do. And we came up with a pretty good list of things that we could do. The most important thing was asset verification. It was very difficult to verify assets for asset management firms before that. Banks would say, "Oh, this is private information. I'm not going to," or they delay in getting back to us, and it was not an easy process to verify the existence of assets. That needed to change, and in my mind, the auditors of this type of firm needed to change. They needed to be, PCAOB registered. They needed to be of high caliber, and the auditors needed, as part of their audit process, to verify assets. That seemed to me to be the best outcome. So I had many meetings with many accounting groups, policymaking groups, along with trading and markets you have to do this. This is really important, and the process doesn't move so fast. So I spent a lot of my time doing that, as well as sending examiners out on site in these surprise exams to verify assets, just to make sure that assets were there, that they do just that. And that we did nationwide, we did across the country. It was incredibly time consuming. We also reiterated our exam modules about fraud and the indicia of fraud. Examiners are pretty well versed, I think, in fraud, but I think, really upped it. Examiners became certified fraud examiners.
Did you look for investment companies like Madoff's? Did you look for and try to say, well, if his firm looked like this, so we're going to check these people? Did you find anything?
Yes,
like
we found a couple. Alan Sanford case came up about that same time, and then there was a smaller one in California, I think, that came up. The other thing, I had this idea that we should, something that CorpFin had done many years in the past, was to require firms to attest to the SEC that their controls were in place and their assets were what they said they were. So I spent a couple of months working on that as a project to require asset management firms, broker-dealers, to come back to the commission and attest. And that ultimately never went anywhere. But the commission has made rulemaking changes in light of Madoff, and that's a good thing. Examiners made changes to their protocols. It's now, and auditors now do verify the existence of assets during audits, and they communicate with the SEC staff that they've done that. So there are definitely lessons learned. And then fundamentally, we did not examine, for me, fundamentally, we didn't examine the asset management side of his operation. And I think if we would have, I like to think we would have found the fraud. We had, or in the early years, a protocol where newly registered advisors are examined in their first year. And that fell away when we lacked the resources to do that. So that was, for me, that was another lesson. Having the resources to be able to go into a newly registered advisor and check it out.
Okay. So I know enforcement after Madoff, essentially, the idea was just kind of blow it up and start over again, build something new. Is that what happened with OCIE? Did you, sort of leave all these things and say, here are the pieces, here's what works, and bestow them all on your successor to rearrange, or how did that work out?
Well, what enforcement did was it created specialized units, which were dedicated to particular issues where expertise, including investment advisor, investment company, specialized units. That's super consequential. I left in place ideas that I had, and I had a roadmap for what I wanted my successor to do in the next year, which I left, a big, thick document. But it was up to somebody else at that point. I felt like I had done all that I could do. I left in June of 2009, having put in place a number of these things, and I felt it was the right time. I also felt that, the new chairman needed to have a clean slate, post this terrible period, and I had been doing the job for 14 years. So it was the right time for me to leave. It was very difficult, but it was the right time for me to go. I mean, I had thought about leaving the agency prior to this many times, but I always felt that there was a risk that OC could be put back into the divisions. There's always this possibility, and so I thought, no, I'm not leaving now. I'm not leaving. I'm keeping this thing going. So, by that time, a new chair, I didn't think it was likely that OC would be eliminated.
Okay. And now we know that OC's made it to division status.
Yes,
so
I'm so
safe.
thrilled. Oh, it's such a vindication of all of the good work of examiners, and that the agency knows their value to make it a permanent division. It just, it's nomenclature, really. When we first started out, it was going to be a division, but trading and market regulation and investment management wanted it to be an office. So I said, okay, I don't care. It's just the name. But now I think it does matter. It does matter to examiners. It really does. And so I was really thrilled and grateful to Chairman Clayton and Pete Driscoll, who was the OC director last year when it happened.
Terrific. So this has been a great talk. Is there anything that we haven't brought up that we should talk about to wrap up?
I think what I did after the SEC, because the SEC really influenced me after I left the SEC. It was, a core part of my psyche. I initially went to PricewaterhouseCoopers and I did compliance consulting for all different kinds of entities, and that was really fun to be, kind of on that side of the table, working with management on compliance programs. And I did that with a former commission lead examiner in New York, Tom Bialsi. We were co-leads of PwC's asset management regulatory group. And then I left PwC and I became a chief compliance officer myself at JP Morgan Asset and Wealth Management. So covering both, the wealth management side, broker-dealer side, and obviously asset management, funds, private equity, everything, soup to nuts. And that was fantastic for me because I got to finally put in play all of the things that I had talked about when I was in OC. I got to actually do those things and remember those things and use those things. And I could see how difficult it was being in that chair. But I loved that work. It was the firm was fantastic. It's a firm where they're expansive. You can get anything done you want. I talked about how it's difficult to send out 120 exam requests to the mutual funds. JP Morgan, anything goes. You can do anything. And so that was really refreshing. I had lots of resources, and I really enjoyed my time there and being a chief compliance officer.
Did you learn anything and call up your successor at OC and say, hey, given my new experience, think about this?
I did not. I learned a lot. I learned a lot about the business. I think when you're a regulator, you're obviously looking from the outside in. You're never going to be, in the chair where they're talking about their new marketing program or, this conflict of interest or that conflict of interest. But I was there in the middle of it, doing it. And that was, I don't think I could have had as full of a career as I have unless I had been in the trenches as a chief compliance officer. It really kind of closed the circle for me.
Well, terrific. I guess we can close the circle on this interview. Thank you very much.
Thank you, Ken.